Okay, so well, thanks for inviting us today to your call.
Oh,
I
you're
believe it was
welcome.
about a year ago, last April, we were on the call. Thanks for inviting us back. So, well, I'll introduce ourselves, I guess, as we start speaking. My name's Robert Kennedy. Work here at BMO Private Wealth, specifically with BMO Private Investment Counsel. And just to give you just a high level view about BMO, many of you know BMO, what we do, fourth largest bank in Canada, and really the team that we're part of, Chris, Bill, and myself, is with BMO Private Wealth. And BMO Private Wealth was created to have these kind of discussions. We found that we work with the bank's best clients, high net worth individuals, and help them navigate through different complexities of money and money management. Right? We find that the more wealth someone has, the more complex things can be, which is one of the reasons we're going to be talking about trust today and estate planning, because there's also, you obviously want to keep as much of that as you have and not give as much away to the CRA as you don't have to. And so that's why BMO Private Wealth is created, to help our clients with that. We have specialists on our team. Chris is one of our specialists that helps our clients. And you can see we have a lot of different services. I've highlighted just three of them. I'm on the investment management side, helping clients manage their portfolios. We manage RSPs, TFSAs, non-registered accounts, RIF accounts, of course, as well. And our clients have access to individuals such as Chris and Bill and many others. We have accountants on our team. We have philanthropic advisors on our team. We have financial planners on our team. So Chris will be talking about trust services today, with a little bit of estate planning wrapped into that. And that's what we're here for at BMO Private Wealth. I can send this out later, but these are just some of the details we talk about when we look at trusts and estates. Every time I meet with Chris, I learn something new, even though I was in a trust group many, many years ago. This is what Chris does day to day. So Chris specifically helps our clients with talking about estate planning and also wills, which we'll get into. So with that, what I'll do is maybe I'll unshare this screen and we can reshare the presentation you had there, Colin.
Okay.
As well. And then we will invite Chris to take over from here, if that's okay.
Okay, I'm sharing my screen. And can you see estate planning with trusts?
It's just slowly loading. There we go.
Yeah. Perfect.
If you're going to just tell me when to change slides.
Yeah, we'll do, I guess. So thanks, Rob, for that intro. I'll just give a little background on myself, I guess, before I jump in. So I'm a lawyer by background. I've been with BMO for over 10 years now. Came from private practice beforehand, so give legal advice to clients, specifically on the discussion we're talking about today with respect to estate planning, wills, trusts, powers of attorney, that sort of thing. And back when I was in private practice, I was also very active in the Ontario Bar Association, and lawyers, doctors, accountants, they all have to keep on top of the latest developments. So I would do presentations like this to lawyers and basically teach lawyers how to do all this stuff. So that's my background. So I'm going to do a very high level sort of discussion of trusts today. And, everybody thinks, well, you have to have tons of money to make use of trusts. And that's not necessarily the case, because there's different reasons to set up trusts. Certainly, if you have a lot of money, then there's certain tax planning strategies and things like that can make sense. But even in all cases, there may be some benefits to using trusts. And so we're going to talk at a very high level over various types of trusts. And then afterwards, I'm going to pass it on to Bill. And Bill is going to talk about how BMO Trust Company, part of the bank, can actually help with management of trusts. So if we flip over to the next slide, Colin, the most important slide from my perspective as a lawyer, of course, is the small print. Nothing we give here is legal advice. Every situation is different. You have to go get your own legal advice, and on we go. So let's bypass this slide now, but that's of course top front and center. So the agenda for today, so we're going to talk about different types of trusts. So there's some types of trusts that we'll refer to as living trusts, and then there's different trusts called testamentary trusts, and I'll sort of get into the explanation of the two different types. And then afterwards, we'll just have some questions to wrap up. So there's different, in all trusts, whether it's a living trust. So a living trust is something that you set up while you're alive. A testamentary trust is the type of a trust that arises after you die. So that would be, for example, a trust set up in your will. Now, all types of trusts have different people involved. So there's somebody called the settlor. That's the person who sets up the trust. And then there's the trustee, of course, who's in charge of managing the trust. And then there's the beneficiaries, and they get the benefit from the trusts. In different cases, it might be the same person fulfilling all three roles. It could be three different people fulfilling the different roles. And we'll sort of get into that as we go through this. The trustee really is a job and has to manage everything in the best interest of the beneficiaries. It's a fiduciary duty. That's the key word that we use legally, a fiduciary duty. So it's not for personal gain. You're holding things in trust for somebody else, and it's for their benefit. And the trustee does the job of managing it. So the money, they distribute, they file the taxes, and they do all that sort of work. The trust document itself is what sets the rules of the game. And so the trustee has to honor whatever rules are set up in the trust document. Keep proper records. They could be sued, for example, by the beneficiaries if they're not doing a proper job. So it is a very important job. And the will or the trust document sets the rules of the game that the trustee needs to follow. So we can go to the next slide, Colin, which talks about living trusts. So living trusts are typically established sort of during somebody's lifetime. They're typically set up for tax reasons, either probate tax or income tax. So on the income tax side, a lot of business owners, let's say they're thinking down the road, they're going to sell the business. There's going to be a big capital gain, and they'd have to pay a big tax bill at the end of it. They can do various transactions using a trust so they can split that amongst family members. So there's something that's called an estate freeze. I'm not going to get into all the ins and outs of it. I'm not sure if that's very applicable to the audience here today, but that's something that a business owner may do. They might do some sort of an estate freeze, and they introduce what's called a family trust, and then that allows the growth, or you can split up the income tax liabilities amongst various people instead of having it all in one person's lap. In some circumstances, it makes sense to set up a family trust if you have, let's say, one person has a high income. Let's say husband has a high income, he's got a wife that isn't working, and he's got children that are relatively young. It might make sense for the husband to set up a family trust, loan funds into that trust, and then instead of having all the tax in husband's hands, who's already got a high income, now he can split the tax bill amongst his spouse and his children and have a tax efficient situation for the whole family. So that's typically where we see living trusts set up for income tax purposes. All trusts are generally subject to this 21-year rule. If anybody's dealt with trusts in the past, you're probably familiar with this 21-year rule. And so when you're setting up a trust, you always have to keep in mind this special rule that may apply to future generations. I'm not going to get into all the details of that here because I'm not sure how applicable that would be in this case. More so, I think it would be for probate tax planning that most of the people on this call may be interested in setting up some sort of a living trust. And so there's different names. So an alter ego trust is what an individual person over 65 can set up. A joint partner or joint spousal trust is something that a husband and wife can set up together. And for people under 65, or even if you're over 65, you can set up some sort of a bearer trust, which has similar features. But really, the whole purpose of setting up these types of trusts, for the most part, is for probate planning strategies. So if you've got a whole bunch of assets, let's say you're just an individual person, you're not married, or you're a widow, and you have a whole bunch of stuff. You have a house, you have some investments, you have bank accounts, and these sorts of things. When you die, all of that stuff is potentially passing through your will. And what has to happen when your executor goes to administer your estate, they have to go to this probate process. And so they have to hire lawyers, they have to pay a few $1,000s to the lawyers, and then they have to pay a probate tax, which is 1.5% of the value of whatever is in the estate. And so if we've got a large estate, this really could add up to quite a significant amount. If we were to put some sort of a trust structure in place, instead of passing through the will of that person, now it's going to go through this trust document, and the trust document's going to say, when I die, give all the assets to my kids, for example. And so instead of passing it through the will, it's the trust that does the distribution. And so we're not subject to probate tax for anything that's in that trust, right? Because probate only arises under a will situation, or if you have no will, then probate's almost guaranteed. But I'm assuming, most people on this call have a will in place. And so when that will has to go and be administered, that's when the probate situation kicks in. So that's a main reason why a lot of people would set up these types of living trusts for probate avoidance purposes. So we can go to the next slide.
Okay. Oops.
Which discusses testamentary trust. So testamentary trust, again, is something that arises on death. So somebody passes away and their will, for example, says, set up a trust for my spouse or for my children. And that's considered a testamentary trust. And there's different types. So one would be for a spouse or a common law partner. These are often seen in blended families. So let's say mom and dad, it's a second marriage. They each have children from prior relationships, and mom wants to make sure her kids are provided for, and dad the same thing. And so what may occur is you might decide to set up a spousal trust for the other spouse because there's income tax benefits to doing that. So if let's say, I'll use myself as an example. So let's say I was in a blended family and I've got children from my prior relationship. If my will says give everything to my own kids, there could be a nasty tax bill at that point. If instead I were to set up a spousal trust and say, while my spouse is still alive, my second spouse, while she's still alive, hold everything in trust for her. She can't touch the capital, but all the income has to go to her. So she gets all the income, and then when she passes away, now it all goes down to the kids. And what we've done is we have deferred that big tax bill that would have been due on my death. Now it goes on a few years when my spouse passes away, and that's when the tax bill is kicking in. So there's some tax benefits to doing that, and I also have the protection of making sure my own kids are going to be protected. So that's often where we see spousal trust planning. Also, if you've got, let's say one of the spouses has a family business that has been passed down from generation to generation, a lot of times you want to make sure it stays in the bloodlines, especially if the kids are involved in the business. And so you may set up some sort of a spousal trust structure in that case to make sure that ultimately the family business assets stay in the bloodlines and down to the descendants. So that's where we would see spousal trusts. Probably for the benefit of this audience, trusts for descendants would most likely be more important. Certainly if you have young beneficiaries, so for people where their kids are relatively young, or if you're leaving something to your grandchildren and they're relatively young, it might make sense to have some sort of a trust structure. So let's say if you've got kids that are teenagers, or certainly if they're underage, for kids or grandkids that are underage, you need to have a trust set up. But even if the beneficiary is relatively young, maybe not so good with money, you might want some sort of a staggered distribution. So you give them a bit now, and then a bit maybe 5 years later, and then the rest 5 years later, to give them a couple of chances, because if you give it all at once, maybe you're concerned that they're going to blow everything. So that's one reason to consider a staggered type of distribution. And this might even apply, let's say if your will says give everything to my children, but if one of them predeceases me, it goes down to their children, so to my grandkids. And that's often what we see in wills. And if the grandkids are relatively young, you might want to consider some sort of a staggered distribution in that case. For your own children, there could be family law benefits to setting up a trust. Let's say you leave assets to your child is in a relationship, they receive the inheritance, and then Mr. or Mrs. Wrong walks out the door. They could be taking some of your assets that you pass down to your child with them. And so a lot of times what people will do in their will is they will set up a trust for their child. And if you have no money concerns, you're not worried that your child's going to blow through the inheritance, but it's strictly a family law type of protection, you can name your child as their own beneficiary. And in that case, it's an added layer of protection for family law purposes if something were to go wrong. Another reason to get back to tax purposes, I'll skip over the Henson Trust for a moment. For income splitting within the family, we did talk about setting up trusts while you're alive to do some income splitting sorts of things earlier. Even in your will, you can set up a trust. Let's say you've got a child that is really well off. They're making a lot of money. They're at the top income tax bracket. And if they receive a nice big inheritance, what are they going to do with it? Well, they're going to go and invest it, and they're going to pay high taxes because they're in a high tax bracket already. So what we can do instead is we set up a trust for that child, and that own child can manage, his or her own trust, and we can use the income that's generated from that trust to sprinkle it amongst the children of your child, so down to your grandkids, to pay for hockey or dance or tuition or whatever it is, at a more tax efficient situation. And then another reason, just above that, where it says Henson Trusts and Qualified Disability Trusts, those would be applicable if there's a disabled person in the family who may be receiving government benefits. And if someone is on ODSP, for example, the Ontario Disability Support Program, and they're receiving benefits under that program, if they receive an outright inheritance directly into their name, they may lose some or all of those benefits. And so if we set up a special type of a trust called a Henson Trust, then that will, there's special rules around that, and it's set up in such a way that the child is not entitled to anything out of that trust unless the trustee says so. So the trustee manages the trust and makes sure that the trustee is not giving too much to that child, to make sure that we don't affect the government benefits. And if it qualifies as a qualified disability trust as well, then we get graduated tax rates within that disability trust for the child. So there's a lot of benefits to setting up trusts, specifically if you've got a disabled beneficiary in the family as well. So that's a whole bunch of different reasons to set up trusts, either while you're living or after you've passed. So that's all that I'm going to speak to right now. I'm going to actually, the next slide just talks about questions and stuff like that. But before we get to that, Colin, I'm going to ask my colleague Bill to speak to BMO Trust Company and how BMO Trust can help with these various types of trusts. And then after he's finished, then we can open it up for questions.
Thanks, Chris. Can you hear me okay?
We can hear you.
Oh, perfect. So thank you very much for allowing us to speak today. As Chris mentioned, part of Private Wealth is BMO Trust Company, where we work with high net worth individuals to assist them in estate administration matters and trust matters. Clients more and more nowadays are looking for alternatives to what was traditionally family members taking care of things like estate administration and being a trustee of a trust if one is set up. What we're finding, 50 years ago, their families lived close together. It was more convenient. Things weren't as complicated. Nowadays, I deal with many clients where, children aren't even in the country. Other couples don't have children. They don't want to burden the children with any of these things because they have become far more complicated as time has proceeded. And so clients look for options of who can assist us in these type of matters. And so BMO Trust Company has the ability to be a corporate executor. So that's where we would be in a client's will, and we would take care and administer the estate once a client passes away. Good things for clients is nothing happens until, typically if we're dealing with spouses, it's the last spouse passes away. Then we will step in and act as long as we're still in the will as the executor, and we'll charge our fees accordingly at that time. So again, nothing's charged until we do something. The good thing is that when those files are assigned to a trust officer, it's someone who does this on a daily basis. So we've got, in the GTA West area, we've got Frank and Sandra, both long-term trust officers. Typically, trust officers do this for long periods of time. And what they're doing is estate administration on a regular basis, but also trust administration as well. Because as Chris mentioned, there's many times where we're dealing with clients and they're doing their estate planning and they may have, again, minor children. They may have disabled children. They may have children that may not be good from a financial perspective and need assistance there, or even children with drug and alcohol problems who they feel that can no longer receive money directly, so things must be in trust. And so the issue is who's going to administer those trusts for them. A lot of times there might be siblings, but parents really don't want to put a sibling in the situation where they control the money of another sibling, because that can cause animosity in the family from those children's perspective. And so looking for an alternative of a group that can come in and manage that. The good thing is we're strictly a third party. We have no interest in the estate. We have no interest in the trust. So we're there as professionals to take care of that on a day-to-day basis. From a qualification perspective, we are dealing with estates that are $1 million and more of probatable assets, meaning assets that flow through the estate. Some people do get confused sometimes if they've got RSPs, RIFs, TFSAs, life insurance. If they name a beneficiary on those aren't governed by the will if it's a beneficiary other than the estate. If you name the estate as your beneficiary, then your executor will deal with that, and that'll form part of the estate. The benefit of having a direct beneficiary is it avoids the will, avoids the estate, and thus avoids probate fees and executor fees. But sometimes, as Chris mentioned, you have a child who's disabled, you need to fund a potential Hansen Trust in their will. Sometimes you need to flow those funds in there. You don't want to have those funds go directly to the child because it may disqualify them from government benefits. So that's where your executor would take care of all of that. During the estate administration, the trust is created and they become trustee as well and go forward and take care of that trust. Where as executor and trustee, we're merely following the directions that are governed in the will, where it's set out of the distribution of assets, and then also what happens with the trust distributions. Certain ones, as Chris mentioned, of the Hansen Trust are much more discretionary to make sure that the child does not lose their government benefits. So we've got a lot of experience in those. So our trust officers are used to dealing with that on a regular basis from that perspective. And we will continue to manage the trust. We oversee the investments in the trust. So typically we're hiring like the private bank, somebody like Rob, to manage those assets because it's very structured, disciplined management, which is ideal for a trust. And we will be overseeing that. We'll be working with the beneficiary to make distributions, whether directly to them or to other institutions. Say there's post-secondary school we're paying for, we'll pay the institution directly. And then we'll also make sure that the tax returns get filed each year. So anything to do with the trust administration, that's your trustee would deal with from that perspective. So the one thing to note too, that sometimes if you do have a Hansen Trust that is set up in your will, a lot of times people forget that there's certain things that we can't deal with. And for that child, it's always good to have in place a POA for the child who would be responsible for making decisions for that child if they're not capable of doing that. It makes it far easier for the trustee to do their job of managing that trust. If necessary, there's a POA in place. It makes it smoother and easier to take care of the day-to-day administration of everything. So, as I said, BMO Trust is here to assist clients in that estate administration and trust administration. So I'll turn it back to Rob.
Actually, Bill, I saw a question pop up. Maybe if you can answer. It was asking,
Sure.
What's the fee for managing a Hansen Trust?
Oh, sure. Typically, when we set up a trust, the ongoing fee is 0.5%. There's a small fee to set up the trust. I think it's $2,000. But then the ongoing fee is 0.5% as long as that trust is in place. So once the trust is no longer in place, then we're no longer a trustee, and that fee will discontinue at that point. That trust fee only kicks in once the trust is created and we're doing the job as trustee, and that typically happens at some point during the estate administration, because typically the trust is going to be funded at some point from the estate.
Would I be right in understanding that's 0.5% per year?
Yes, correct.
Okay.
Now there would be the additional fee on that would be the any investment management fee, because the funds within the trust typically are managed, and so they continue to grow, produce income, whatever is required for the beneficiary of the trust. So there will likely be investment management fees on that, but that would be dependent, the amount of fee would be dependent on the amount in the trust of what is being managed. So as I mentioned, Rob could manage a trust, and so that BPIC would charge a fee accordingly. And again, that would be solely dependent on the assets that they're managing to determine the fee.
Okay. Thank you very much, folks. This is I'm always learning more when we have these events, and trust was something wasn't really on my radar screen, but it's obviously an important part of planning in an estate. Now I'm just having trouble seeing the chat. Can you check to see if there's any questions in there? Oh, I just got
Actually,
it.
Colin, I see there's a question, and Bill, maybe we'll put it back to Bill. It says, what happens if the trust company goes out of business?
Hopefully they don't. Usually, I mean, there's no guarantee that any business won't go out of business. The nice thing is BMO's been around for 200 plus years, so we don't foresee BMO going out of business anytime soon. The trust company's been around since 1992. It's not a massive trust company. We typically are smaller to manage the clients. We're not trying to be a huge trust company by any means. But what I've always witnessed in the past is if a financial institution like a bank or a trust company was in any kind of financial issue, and the government would allow it to likely take over from another FI. So that trust company would take it over and likely then just replace BMO Trust as the trustee. But I don't, there's no crystal balls, but I don't foresee it after, again, BMO being around 200 years that anything's going to be happening anytime soon.
The other thing, if I can just chime into Colin and Bill, is when we invest money for all of our clients, whether it's a trust or anything, the money's actually held in trust, as in it's not part of the bank's balance sheet to do what it wants with. It buys individual stocks, bonds, private equity, whatever. So that money is held off balance sheet. So Bank of Montreal did go bankrupt. It's been 200 years. Then that money is actually separate from the Bank of Montreal itself. It held at the trust company.
I see. So separate pool of money.
Yeah.
Yep.
Not accessible to creditors because it's client deposits. It's not our asset.
Okay.
Yeah. If I could just add to that as well, I think there was, I can't remember what the name of it, but I think there was a trust company years ago that either went out of business or merged with another company or did something like that. And the new trust company basically just took over the roles and responsibilities of the old trust company. So it's not something to really be concerned about. There's a very high level of government oversight over these things, and it's not the sort of thing to really worry too much about.
Okay. I think I see a question from Susan in the chat. If a person passes away and specifically does not want a grandchild to receive anything from the estate, but does want the child to inherit, is there a way to ensure the child does not provide any of their inheritance to the grandchild?
That's a good one.
Hmm.
Once you give it to your child, it's theirs and they can do what they want with it. So from a legal perspective, you can't really handcuff them and say no, you can't give any to your own child. That's more of a sort of a moral side discussion that you would want to have with your child.
Hmm.
Um, and if you really, really want to put the handcuffs on, you can have somebody managing a trust for your own child, and don't actually give money to the child, but just pay stuff for the child. Right.
Yeah.
So if you set up a trust, your trustee doesn't necessarily have to give the beneficiary the money directly. They can pay expenses for them. Right. So
Right.
your child needs to make a mortgage payment out of the, or whatever it is, or buy a car or like whatever it is. The trustee can actually pay directly for that expense on your child's behalf instead of giving cash to the child. So you can, I suppose you can really, really make things complicated if you want. But I think the easier, most practical solution is just to have a discussion with your child and hope that they abide by your wishes.
Okay.
Next question is from Carmela.
Chris, what is the discretionary amount given to a disabled child for it not to affect government benefits?
That's a great question. So under the ODSP, there's an income test and an asset test. And so the disabled person can only earn so much, receive so much income in a given year, and they can only own so much assets at a point in time without affecting their government benefit. And those numbers sort of change over time. I remember back when I was in private practice, I think it was about $6,000 a year of income that they were entitled to have. I think it's more now. It could be 10 or 15,000. I don't know offhand. But that's easily something you can check out online to find out what the current numbers are, because they do change from time to time. But it's a great question. But that's one of the reasons why it's important to have a trustee that understands these things and can make sure that they're not going over that limit.
I can chime in on that just a little bit too, Chris. I actually have a gentleman who has a LIRA, which is a locked-in retirement account, and usually you have to be 55 years old to use those LIRAs. He's under 55 and does have ODSP. We found out the amount was 12,000. So I think Chris, we just said that 10 to 12,000. So it was 12,000. So what I did, we had to apply to take money to the LIRA under a financial hardship provision. We took 11,000 just to be safe in case there's any interest in a bank account. There wasn't, but you never know. And then we had to apply through the Ontario, I guess, minister to be able to get that money locked out so as not to affect the ODSP. It was really the medication. I think, Chris, is the big deal, losing that medication, as well as also the cash benefit too.
Yeah, you're right.
Lionel's asking, is a power of attorney for personal care needed or recommended? I was thinking of is a POA for property all that's needed, and any information on how it could be triggered or revoked?
A great question. Yeah, it's generally recommended to have both. So a power of attorney for property and financial decisions, and a power of attorney for personal care and health decisions. If you don't have any powers of attorney in place, under the personal care and healthcare side of things, there are some default rules out there in the legislation that will allow certain family members to make decisions for you. It's still better to have your wishes expressed in your own power of attorney for personal care rather than the government's default rules. Nobody wants the government making decisions for them, right? So yeah, it's best to have a power of attorney for personal care. If you don't, there's still default rules that say your spouse or common law partner or your child can make these decisions for you. So it's not end of the world if you don't have a power of attorney for personal care, but it is good to have it. On the other side, for property, if you don't have a power of attorney for property, it's messy. When I was in private practice, I dealt with multiple situations where somebody died without a will, or where somebody lost capacity and didn't have a power of attorney in place for property. And it's worse, in my opinion, it's worse to lose your capacity and not have a POA for property than to die without a will. Because again, if you die without a will, there's default provisions that kick in, and they're not ideal, but they're there. On the property side, if you lose capacity, somebody has to apply on your behalf, and it's a court appointment. And they have to apply to court. You have to generally hire lawyers. They have to prepare like a 60-page management plan. How are you going to manage all of this person's property for their benefit? Very detailed, very lengthy, very expensive. It's really a bad situation. So short answer is yes, it's best to have both. More vital to have the POA for property. And then the end of the question was, how is it triggered and can it be revoked? All your powers of attorney, while you still have capacity, you can certainly revoke them and sign new ones, right? So that's you can do that in either case. In terms of triggering on the power of attorney for personal care, it only triggers when you can't make your personal care decisions for yourself. On the financial side, you can have a triggering mechanism, or you may not have a triggering mechanism. Depends on the terminology in the document. In most cases, you don't have a triggering mechanism. You just say it's effective today. I signed it today. It's effective today. If you do have a triggering mechanism, such as it only applies if I lose capacity, and then let's say a few years down the road, you're kind of losing your capacity. In order to get a formal capacity assessment, you have to agree to it. And if you're in denial, you may not agree to it. We might never actually be able to actually use this power of attorney because you don't want to admit that you're suffering from issues. So in most cases, we would just say make it effective immediately, and then it's available when it's needed.
Interesting. Okay.
Next.
Kushru's asking, hypothetically, if I wish to say give $100,000 to a son or daughter now, but actually I'm a little confused here.
But he or she can only access the funds in case of my dementia, or if they have if they have a financial emergency, what kind of trust should I set up, and what will be the management fee?
So if we want to give $100,000 to a child, but it has to be limited access, then that would be some sort of a trust structure that you would be setting up now while you're alive. But typically you'd need to have somebody else managing it in order to, you can't have the child managing it, because then they could just go and do whatever they want with it. So if you have a third-party trustee, like Bill was talking about earlier, Bill can speak to what the fee would be. But if we set up that sort of a trust today, I guess we'd be looking at, what would be the reason for setting up the trust? Is it just to have the money set aside so it's there if they need it? Maybe Kushru, if you can unmute yourself and explain more of the reasoning.
Yes, that would be true. It would just be so that the son or daughter does not blow the money, but it's there if I die or if they have a financial emergency.
Yeah, I'm not quite sure why we would set up a trust, because trusts are a bit cumbersome, right? You have to pay a lawyer a few $1,000s probably to get it all set up. You have to file separate tax returns for the trust every year. In most cases, I think it would just be easier to just sort of have the money in your own name available. If the child has an emergency, you can just give them money instead of setting up a formal arrangement for it. You can consider setting up a joint account with a child, although there's a lot of downside to doing that sort of thing as well. Does that answer your question, Kushru?
Yeah, the question is, again, very simple. Is I want to leave some money for a son or a daughter and have it set aside, as you mentioned, but they can only access the funds if I pass away tomorrow or if they have a financial emergency.
I think he's talking about setting up a trust for the kid.
If it's only available on death, that would be through your will, right? So
yeah, that's the will is already there, so it's in there. But it just so happens then it would ensure that that money was there. But again, that would be defined in the will. Correct.
Right.
Okay. All right. Anyway, thank you very much. Appreciate it.
Sure. Yeah, my pleasure.
Chris, Bruno here. Can I ask a question?
Sure, go ahead, Don.
Just on that last one, I think the question is, can you set up a trust for a dependent? So when you pass, that money's managed according to your wishes.
Oh, 100%. Yeah, absolutely. If there's somebody that's financially dependent on you, you actually have an obligation to provide for them, or else they can disrupt your estate. And it's a question of, do we just give them money directly, or do we set up a trust? And again, depending on their situation, maybe it does make sense to have a trust where you've got somebody managing it for them, for their benefit. So absolutely, if you've got somebody that's dependent, a trust would make sense in your will.
What about this?
Trust for them. It would be a
Yeah.
trust for them, not
Yes.
your.
Andy? What
It's
about,
a follow-up question. You have
do you
an
want
ordinary
to?
pensioner.
Okay.
Can't hear you, Bruno.
Okay. Marilyn, can you mute yourself?
What?
I just want to look at it from a financial perspective. If you just have an ordinary person who doesn't have any special need children or whatever, just looking at it from an economics point of view, how do you go about determining the financial advantages? Like you're saying, the advantage is to avoid probate, right? But you're paying 0.5% per year to avoid a future payment down the road. How do you?
Well, you wouldn't be, Bruno, if we're talking about one of those alter ego kind of trusts where you would be managing it yourself, right? And you would be the trustee, and you would be the beneficiary, and you'd be the person setting up. You're all three of those people. And I'm sorry I didn't make that clear when I was speaking earlier. So these probate avoidance sort of trusts that you set up while you're alive, you're in charge of it immediately, right? So Bruno decides, hey, I don't want to have all my assets go through probate. I set up, Bruno's going to set up his own trust. He's going to be the trustee and the beneficiary. And in the trust document, it's going to say, well, if Bruno loses capacity and he can't manage things on his own anymore, then we've got a backup, spouse or child or whatever it is, stepping in. And so somebody else is managing it. And at the end of the day, we avoid probate because it's all in that trust. So there's no real fee unless you've got a third party acting in there.
But I'm talking about a third party arrangement where you're paying 0.5% a year to avoid a probate fee down the road. How do you go about determining if it's worthwhile to do that? Just from a financial point of view, does it make sense?
Yeah, I would say to set up one of these sort of trust arrangements for probate avoidance, the estate would have to be worth several $1 million, I would think, before it makes sense. Because you're paying the trustee fee, you're paying you have to file tax returns every year, plus a few $1,000s to set it up initially. Yeah, so it would have to be a good size estate if you're having a third party in there. If you're not having a third party in there, and it's just staying within the family in terms of managing it, it may be available for a lower size estate as well.
Well, let's stick with the third party option here.
Okay.
So say someone owns a house, a couple of $1 million. They might have $1 million in the bank. They might own a condo. At what point do you say, yeah, that's worth doing it from a financial perspective? Is it 5 million, 4 million, 8 million? What's your sense?
I'd say certainly north of 5 million for sure. It would make sense.
Okay, that's my question. Thank you.
And it also depends on your age as well. For a 90-year-old, it makes all the sense in the world to set it up. For somebody who's 65 years old, well, we've probably got 20, 30 years left of paying tax filings and everything else for 30 years. Maybe it doesn't make sense for somebody who's 65, right? So it's age dependent, it's asset dependent. Which is why at the beginning I said, every situation is different, right?
So it's north of 5 million and maybe greater than 85 or something. If you don't have any other special needs.
Yeah, like I said, every situation is different. And in some cases, if it's a married couple, maybe you wait until one person has passed away. Like there's a whole lot of different things to consider. There's no one size fits all.
There's a question on chat. If you have a joint bank account, joint with an adult child, is it considered a bare trust introduced a couple of years ago by CRA, but was not put on hold?
Yeah, no, that's a great question. That was the prevailing thinking when they released the rules initially, that all these joint accounts were going to be subject to extra tax filings for these bare trusts. And they keep changing the rules, and everything is, as was mentioned in the question there, it has been put on hold for now. I can't speak to exactly where it sits right now. It's not in force as of yet. And they were going to be making certain exceptions for certain types of situations that are interfamily. But yeah, you'd have to look into that. I don't know exactly where that's going to land, and it's not in force yet.
Okay. How to offset business capital gain by using income splitting?
Yeah, so let's say somebody's running a company, they've got a private company, they own shares of the company, and they're going to sell that company. So they set it up for zero. They're going to sell it for a few $1,000,000. There's a whole big capital gain there that they're going to have to pay tax on. And so what they could do at some point along the way is introduce other family members as owners of the company. And the way you do that, it's a complicated tax transaction where you take back preferred shares, and then you have a family trust that subscribes for common shares, and all this sort of stuff. And at the end of the whole thing, you've now got more shareholders that can share the capital gains exemption, which I believe is about 1.25 million right now per person. If you can spread that amongst various family members, there's a tax benefit to doing so. It's a complicated structure, but it could certainly save a lot of money for the family.
Janice, are you trying to put something on chat?
Nazma, I think Janice was asking just to understand better, elaborate on how income tax on a trust works.
Yeah.
Yeah, so a trust is considered a separate taxpayer.
Okay.
Right. So an individual, you and I, we all have to file taxes. A corporation is a separate legal person. A corporation has to file taxes. Just like a trust is considered a separate taxpayer by the CRA, and so they've got to file their own taxes as well. So it does add a little bit of complexity.
Okay, thank you. Because I didn't think you were earning interest on the trust account.
It depends what type of trust we're setting up. So if we're doing one of these trusts for probate minimization, it's basically a flow-through trust, and the trust is really doing nothing. It's not really generating its own income or anything like that. So the tax filing is pretty simple, but you still have to do the tax return, right? So there's still an expense of getting that done.
Okay, thank you.
So, Chris, if you have a power of attorney in place for both personal and property, and then you also have a will that specifically divides between the children, and all the children are adult, how do you help them to save on the tax part? Does having a life insurance that when you die, the money you get from the life insurance would pay towards any taxes they have to pay? Would that be a good idea?
That's an excellent idea. Depending, especially on, like every case is different, sort of a thing. But if you have the way your assets are structured, your kids have to pay the tax anyway. So you die, there's a tax bill due.
Mm-hmm.
They're going to have to find the money somewhere.
Right.
And if you have life insurance available, it's quick and easy. They get a big check and they just pay the tax.
Right.
It's nice and easy. Especially for somebody that owns a lot of real estate. We deal with a lot of clients and they own, some rental properties and things like that. You don't want to be in a situation where you're having a fire sale and they have to sell some real estate quickly, especially in this market right now, to try to pay the taxes, right? So life insurance is great for that. It's instant, give them a death certificate, they cut a check, and the money's there and you can pay the tax with it. So it's definitely a good strategy.
In this particular case, there is no trust needed to be set up.
Correct. Yeah. But all the life insurance is doing is paying for the taxes. Trusts can be used to reduce the amount of taxes that would have to be paid. Right. That's the idea.
Thanks. We have a question. I understand the cons and repercussions of giving cash to children in advance of death. In Canada, is there any rules or tax for giving cash gifts?
No, you can do whatever you want with your stuff. There's no tax in giving to a child, for example. In the States, it's different. They've got a gift tax. We don't have that regime here in Canada, so you can do whatever you want with your stuff. The only tax that might kick in is if you have to sell something to generate that cash. But if you've got a bunch of cash sitting in the bank, you can give it to your children and there's no tax on that.
I have a sizable RRSP account. How do I set this up for a trust fund?
Yeah, so you generally don't do anything with RSPs. That's a special sort of situation. You wouldn't be doing anything with respect to trusts when it comes to RSPs. This would be for other sorts of assets that are not parts of registered plans.
For RRSP, you can have your beneficiary as children, but they'll still have to pay tax when it's withdrawn, correct?
Yeah, absolutely. Your estate is still responsible for the tax. It might bypass probate and get to the kids, but there's still income tax payable.
I don't see any more questions on chat. Is there anybody else who wants to unmute and ask questions?
I had one actually.
Go ahead.
Chris, you got me curious. You mentioned trusts are subject to a 21-year rule. Is that something you can give us the high-level explanation of what it is?
Yeah, so generally when you set up some sort of a trust, the general rule is every 21 years, the trust is deemed to dispose of whatever assets are in it at fair market value. So let's say you put a bunch of money in a trust, it's invested, it grows over 21 years. You haven't really paid any capital gains maybe on the growth in there, on the capital, right? The capital, let's say there's like putting income, there's income in capital, put the income to the side now. We're just talking about the capital.
Okay.
It's been invested. The capital is now worth a lot more. You've never paid tax on it because you haven't sold it. That's when you pay tax when you sell something. So the government deems that you sold it after 21 years and you got to pay the tax at that point.
Okay. That's
Right?
just to avoid money being squirreled away for forever.
Forever. Yeah. For generations and generations and generations. That's the concept.
Okay. Oh, interesting. And you mentioned there's two main types of trust, the living and the testamentary trust. My understanding is when a person passes, normally any of their investment assets they would be deemed to have disposed of at or near the date of death, and tax would be payable on those assets. Is a trust a vehicle to avoid that type of tax, or is that sort of out of scope?
No, the tax is still payable when you pass away.
Okay.
You can't really get away from that. Like the whole estate freeze thing that I mentioned earlier is a concept where business owners can sort of, you can cap your gains now and all the future growth goes to the kids. Like that's one sort of thing you can sort of do with businesses. But generally with non-registered investments and rental properties and that sort of thing, you don't really have that type of planning available.
Okay.
There was a question on this one here. I think Robert answered that. The next question is, what is an alter ego trust?
Yeah, so alter ego trust. So that's one of those trusts to avoid probate, right? So let's say Colin has a bunch of money sitting in a non-registered investment account, and he says, I don't want my kids to have to pay probate tax on this. And so what he does is he sets up an alter ego trust. So Colin sets up the trust, and Colin is the trustee, and Colin is the beneficiary during his lifetime, right? So it's kind of a flow through thing. So all the stuff, so he was paying tax on it all along during his lifetime. He sets up the trust. He's still paying the tax on anything that's generated in that trust. But instead of it going through his will, now it goes through the trust when he dies. And so we bypass probate. That's the idea.
The question I have is a tax-free savings account. Robert answered that if you put your spouse as a successor holder, they can get the money. What about putting this tax-free savings account to the children if there is no spouse? How does that work?
Yeah, Rob, did you want to speak to that?
Yeah, so they can, if you put your children, they will get the dollar value of the TFSA, but they won't go into their tax-free account unless they have room.
Okay.
If you give it to let's say you have 100,000, your spouse has 100,000, you pass away, you can move your 100 into the spouse's 100, they now have 200. If you now have 200 and you pass away and you want to give it to your kids, they get the 200 cash, and they can put it in their own TFSA subject to their room, but they can't add it to their, they have to take it in cash value, and then they can do what they need to with it.
But they don't pay tax on it.
That's correct. A tax-free savings account always is tax-free unless you're
in order to do that, so in order to do that, you have to change your beneficiary to say you want it to go to the children if you don't have a spouse anymore, correct?
You can name your TFSA beneficiary with the institution, like say you're investing with us, you can name it with us. I believe, Chris, you can also name it in your will. Regardless, it would be tax free, but it may not be probate for you, right, Chris?
Yeah, it's generally advisable to go directly to the bank and put your RSP, TFSA, all those designations directly on the bank forms. You can do those things through the will, but it's cleaner if you just do it directly with the financial institution.
Okay. I think that's it for chat. There's no more chat. Any other questions? Anybody? Audrey, unmute yourself, Audrey. Unmute yourself. We can't hear you, Audrey. Sorry, unmute. Can you unmute yourself? Not yet.
Oh boy.
No, you haven't unmuted. Audrey, we can't hear you. We can't hear you.
Somebody's got a TV on.
I think it's coming through Carmela, maybe.
Oh, sorry. I unmuted myself because I wanted to ask a question. But
yeah, good. Go ahead.
Sorry about that. So, sorry, is Audrey asking a question? Or?
Yeah, go ahead.
Okay, thank you. First of all, I want to say that was an excellent presentation. Thank you, Chris, Rob, and Bill. So if we wanted to go ahead and say meet with BMO, who would we contact?
Yeah, we recommend that you we'll send out the contact information for Bill Easton. Bill, you're still there, right?
Thank you.
Yeah, I'm still here.
So Bill's been with us for 100 years, and he knows everything about the banking. And we're the sorry, Bill.
Did you see how he aged you, Bill?
so Bill knows the best place at the bank. Depending on your question, we have different parts of BMO where the best place might be to be. And so Bill has contacts with everyone, whether it be commercial, trust and estate service, investment management, banking, commercial, everything. So that's why we would highly likely recommend you reach out to Bill Easton.
Okay, and you'll provide his details later?
Yes, I will send the details to Colin as well.
Myself, yeah.
Yeah.
Thank you.
We'll arrange to distribute that.
I can send that out. Yeah, unless you already have it, I can send it out.
No, please do. There's a question from Karen. Why does probate fee apply if you have a will?
Yeah, that's a great question, and a lot of people think that as long as you have a will, you don't need to go through probate, and that is not true at all. So, probate is not required by law, right? There's no law that says you have to go through the process, but third parties like financial institutions, the Land Registry Office for Real Estate, these third parties have their own rules, and it's for their own protection. That they require your executor to go through the process, whether you have a will or not. So let's say you've got a bunch of money invested with Rob in a non-registered account, and then you die, and then somebody comes up to Rob and says, "Hey, Rob, here's the will. I'm the executor. Give me all the money." And Rob says, "Oh, okay, here, take all the money." And then a week later, somebody else comes up and says, "Hey, Rob, I got a newer will. You should have given me the money." Right? And so how does Rob protect himself? How does BMO protect itself? They require probate to make sure that it's the latest will. And there's a whole process that whole probate process is essentially the court rubber stamping, saying, yes, this actually is the last will, and the executor has the authority to act. So that's why even if you have a will, you might need to go through probate.
If you have a person you have an account with as a trust account, and that person passes away, and you get the death benefit, and you deposit in that account, there is no problem. But if you've already closed that account, then in order to have the check cashed, how do you have to go? Do you have to go through probate again? It's a government check for $2,500 of that benefit.
So you're talking about the death benefit from the government?
Yeah.
So it's generally payable to the estate of the person.
That's right. So the state is there's no account for the state. So the person who is the beneficiary, can they cash the check? Because they're asking, it has to go through probate.
Yeah, maybe I'll ask Rob to chime in on that.
I missed the last part there, but typically what happens is, so I am always dealing with an estate. I've been here since 2008. There's always an estate happening, and trusts and guardianships. Typically, what happens is when someone passes away and they're invested with us with us, I usually open an estate account for them, like an estate bank account, or we help them open an estate bank account. And then when they, I think Chris, as you mentioned, that's where the death benefit goes into. You can always put money into an estate bank account, no problem putting money in, but it's the getting the money out. And getting the money out, unless it's a very small balance, we're talking maybe under 30,000, the bank may consider waiving that. If that's the size of the whole estate, which is rare, you would be required to have probate to get the money then back out of the estate account. If that answers the question, maybe I missed the last part.
So you have to open up a probate account then? I mean, a estate account?
Yeah, any executor, Chris, you can correct me, should always have an estate bank account, because there's always items that are coming in or out of the estate. Could be final checks, it could be anything that comes in that they may need to put the money somewhere. Also, when they're ready to distribute the money, let's say the person had money at Scotiabank and BMO and Royal Bank, and they might gather all that money together. Mm-hmm. Before they distribute it, they want to stick it in one central place, which is usually an estate bank account, and then they can distribute and write checks that way. So I don't know other way to do that if you don't do that. Right, Chris? Would that be the best?
Yeah, it's ideal to actually have a proper account for tracking purposes where everything goes in and out of, for sure.
Yeah.
All right. That's it. There no any more questions, guys? Girls?
I want to know if this talk is recorded and available somewhere.
Yes. And we will send out the recording later on.
There is a recording later on.
Yes,
okay.
They were kind enough to let us tape it this time. So yes, this session is recorded.
I'll post
That's
it
good. Thank you. And how do we get it?
You will get an email when and where to go. You will be given a link, but all that will happen later on.
Excellent. Thank you.
Okay. Any other questions?
Maybe we can just wrap up, Nazma, if that's okay.
Yeah.
Thanks.
Yeah,
just lastly, from the practical side of things, like currently helping with many trusts, you can see why we have the experts here. While I do know, I think, a decent amount about trust, even working at a trust company, I'm no Chris and I'm no Bill. And so that's why we have the experts on our team to help us. And we have trust officers. And we all sit on the same floor. We speak the same language, sort of, and we work together to make sure we're delivering on what the trust deed says or what the will says. And there's a lot of questions about tax today. I think Chris mentioned a lot of the trust tax benefits are not like what they used to be. There's not graduated rates anymore. Trusts are taxed differently, but we still see a lot of people using trusts for asset protection, or they want to kind of control how they want funds managed after they're gone, whether that be from a spendthrift trust. I can see that Chris has there, or in many cases we have trusts where they're minor children, and maybe they're not minors, but they don't want them to get the money at 18. And I've seen trusts where at 25, 30, 35, they might get the assets, and then at 35 get the whole thing. So there's many other reasons why people do trusts, really not so much always for tax. Mm-hmm. And again, that's why we have the team here. Bill, did you want to add anything?
Nope, I'm good.
Okay, Chris?
So are you from Meridian? I missed the beginning of this.
No, they are from BMO Wealth Management.
Say it again, please.
BMO Wealth Management.
Thank you.
You're welcome.
Thank you.
Anybody else? Again, thank you all very much for taking your time to give us this Zoom presentation. Excellent. Thank you so much, Robert, Chris, and Bill. Thank you very much.
Thank you indeed.
We will keep on having you back on and on and on every time, because you've given us so much information.
Thank you.
Our pleasure.
Nice afternoon.
How can I be?
And I'd like to echo that. Thank you very much as a participant. Thank you very much.
Yep.
Appreciate
it.
Thank you.
Bye.
Bye.
All right. Bye.
Okay. Bye, everyone.
Bye. Thank you.
Bye, folks.
Bye.